Your attention, please. It is my pleasure to introduce the speakers with a line under the S, the speakers of the next topic. They will be John Douglas McCamus, Dean of the Osgoode Hall Law School at York University, and Peter D. Maddaugh of the firm of Torrey, Delory, and Binnington. They have collaborated, is that the word? On a paper on problems in the borderland of tort, contract, and restitution. We asked them originally to do a paper on problems in the borderland of tort involving contract and restitution, and they said you have to broaden the subject because it is broader than tort. So the subject you are going to hear today involves three areas of law: tort, contract, and restitution, but very much to do with torts in the 80s. Now, very briefly, I want to introduce these two gentlemen. John Douglas McCamus, who will be the first speaker, I've said is Dean of Osgoode Hall, came into law through Western, U of T, and the University of London School of Economics and Political Science. He articled with Faskin Calvin, was a law clerk or legal secretary to Mr. Justice Laskin, called the bar in '73, has been at the Osgoode Hall Law School since that time, now Dean. I won't read you the 17 lists of publications of his that I have before me, and the case books which he has written with both Peter Maddaugh and himself. Now let me come to Peter, who will follow John McCamus. Came into law through Queen's University and the University of Toronto, which he received a master's degree in history, an LLB from U of T, and an LLM from Harvard. He taught law at Osgoode Hall Law School, York University, from '69 to '75, and since that time has been a partner and a busy practitioner in the firm of Torrey, Delory, and Binnington. Now those are your two speakers, and I'll leave you in their very capable hands. John McCamus.
Thank you very much, Mr. Chairman, for that overly kind introduction. Peter Maddaugh and I debated at some length how we might present a paper jointly on this occasion. I thought that it would be an interesting departure for the annual lecture series if we could present it responsively, paragraph by paragraph. We couldn't agree as to which would play the Anglican cleric, however, so we've decided to split the thing down the middle, and I will try to spend 20 minutes or so on the first half, and Peter will spend 20 minutes or so again on the second half. Well, for those of us who share, I assume we all share, an interest in the private law of obligations, these are very interesting times indeed. We are variously told by our more speculative academic colleagues that the law of contracts is dead, or at least dying, that the law of contract is going to be swallowed up by the law of torts, or perhaps Professor Attia seems to think by the law of torts in league with the law of restitution, or some say more generally, this entire scheme for organizing the law of obligations is going to be thrown out and will remap the whole thing on the basis of what always turns out to be as yet unclearly identified new principles of liability. Well, whether any of this has any substance to it or not, it is clearly true that the law of obligations is enjoying if you're an academic, enduring perhaps if you are a practitioner, a period of remarkable growth and change. Although the basic principles defining the scope of the law of contracts would probably remain recognizable to even students who studied the subject during the past century, there can be no doubt that much in that subject has changed and many familiar principles are under increasing attack. The law of torts and the law of restitution, I would suggest, are simply unrecognizable. The basic principles of the law of torts have dramatically changed and indeed continue to do so. In this century, of course, the disappearance of the privity requirement through Donoghue and Stevenson, the dramatic revelation in Hedley, Byrne, and Heller that liability could be imposed in tort for economic loss by negligent misstatement, resulting from negligent misstatement, are among the most important changes. The latter development has considerable significance in the context of contractual relations, and at least two of these implications will be considered in our paper in greater detail. But by way of demonstrating the capacity of tort law for continuing dramatic change, I wish to draw to your attention, on the assumption that you have not already discussed this in this lecture series, to a recent decision of the House of Lords in Junior Books Limited versus Vici Company Limited, in which their lordships recognized the existence of a cause of action for pure economic loss resulting from the supply of a defective product. The plaintiff had hired a building contractor to erect a factory. The latter, in turn, hired a subcontractor to lay the concrete floor, and the floor laid by the subcontractor was of poor quality. The owners brought an action against the subcontractors in tort, alleging that the floor was defective as a result of negligence in laying it, and claiming the purely economic loss resulting from the need to repair the floor. The defective floor, I emphasize, did not occasion physical injury to the plaintiff's employees or anyone else, nor did it occasion property damage to other assets of the plaintiff. Nonetheless, the House of Lords allowed the claim. Counsel for the defendant, no doubt anxious to persuade their lordships that this was not an appropriate occasion to push the law forward in the general direction of his client at least, argued that the implication of holding in favor of the plaintiff in this case would be that in the famous old decision in Donoghue and Stevenson, the consumer would have been able to sue the manufacturer in tort for the diminished value of the bottle of ginger beer, even though no physical injury or property damage had been occasioned. Well, this, no doubt, is thought to be a pretty winning argument. This makes it sound very much like a warranty liability, which is to be imposed of the kind which we would normally impose only under the provisions of the Sale of Goods Act or pursuant to the agreement, and not the sort of damage claim that would be allowed in tort. Well, notwithstanding the obviously dramatic nature of this change in English law, the House of Lords did, in fact, impose a duty on the defendant to compensate the plaintiff for the economic or financial loss resulting from the supply of a defective product. It is of some interest to a Canadian audience that in reaching this conclusion, their lordships had occasion to examine the decision of the Supreme Court of Canada in Rivtow Marine versus Washington Iron Works, with which no doubt most of us are familiar, in which a majority of our own Supreme Court refused to take this particular step. The position of the majority was that where the defect in question gave rise to the prospect of physical injury or property damage, and the manufacturer has knowledge of this, a duty to warn might arise, and economic injuries sustained as a result of failure to warn might be compensable. Chief Justice Laskin, in dissent in Rivtow, been prepared to hold that foreseeable economic loss, including the cost of repair, could be recovered, at least in a case where the repair was necessary to avoid the possibility of personal injury or property damage. In Junior Books, then, the House of Lords expressed the view that they found the dissenting opinion of Chief Justice Laskin more persuasive than the judgment of the court in Rivtow Marine. Well, obviously, given the relatively recent vintage of the Rivtow Marine case, it would be unwise for me to predict that Rivtow Marine will enjoy an early demise and replacement by Junior Books. Nonetheless, I think the Junior Books decision eloquently makes the point that the law of torts is continuing in its process of dramatic reshaping. Well, if the modern law of torts would be largely unrecognizable to the 19th century law student, at least the name of the subject would have a familiar ring. In the case of the law of restitution, however, the title of the subject and its basic analytical framework is very much a product of the 20th century. It was the inspiration of two great American law professors, Austin Scott, known to you as the great trust scholar, no doubt, and Warren Seavey, both of them at Harvard, to bring together, between the covers of one book, the law of quasi-contracts and the law of constructive trusts, and to try to treat them together as a coherent field of law. This enterprise was undertaken in the 1930s and resulted in 1937 in the publication of the American Law Institute's Restatement of Restitution. The restatement, document I hope which will be familiar to many of you, in its opening sections attempts to identify the general principles of the law of restitution, the most important of these being, in Article 1, the unjust enrichment principle. That is to say, a person who has been unjustly enriched at the expense of another is required to make restitution to the other. And the subsequent sections of the restatement then go on to restate, of course, and to some extent rationalize the then existing case law of constructive trust and quasi-contracts around these general principles. Well, I guess many of you have heard this story before, and I will be very brief. As is well known, an important feature of this exercise was to pry quasi-contracts loose from its misleading moorings in the law of contracts, and to pry constructive trust loose from similar ties in the law of trust. Quasi-contracts had suffered from confusions born of the notion that quasi-contracts were somehow like real contracts, resting on the intention of the parties, albeit an implied intention. Constructive trusts were generally thought to be in some indescribable fashion rather like real trusts, although people were always a bit vague about just what sort of trusts they were. The reality noted by Scott and Seavey was that in both of these areas of the law, obligations were simply being imposed, quite regardless of the intentions of the parties, in order to prevent what could be described in a general way as an unjust enrichment of the defendant. Well, it's a remarkable fact of Canadian private law, modern Canadian private law, that the unjust enrichment theory and the basic plan of the restatement of restitution has been adopted by Canadian courts as a judicial restatement of the law of quasi-contracts and constructive trusts, the most important authorities being a series of decisions of the Supreme Court of Canada, commencing with Degelman and Guarantee Trust in 1954 and ending with Petkus and Becker in 1980. In Petkus, for example, the Supreme Court acknowledged that the principle of unjust enrichment, as it was said, lies at the heart of the constructive trust and made the constructive trust remedy available. This famous case, of course, is widely known in the quite novel circumstances of affecting a division of the assets of so-called common law spouses. If you went back to look at the Restatement of Restitution or at Austin Scott's book on trust, you would find nothing dealing with the subject of the division of the assets of common law spouses. Petkus was not only a recognition of a very important doctrinal and theoretical point, but its application in very novel and unusual circumstances. While recognition of the unjust enrichment principle has enabled our courts to clear up a number of confusions inherent in the prior quasi-contract case law and has provided a principled basis for the extension of liability into hitherto unknown areas. Well, it's not surprising that these three theories of liability in tort, contract, and restitution are rubbing up against each other with increasing frequency. And indeed, we would argue the satisfactory analysis of private law problems requires of counsel that they have an ability to move easily from one theory of liability to the next in an attempt to fully explore the remedial machinery which might be deployed in a particular fact situation. Although it is indeed true, as these more speculative studies suggest, that the boundaries of these subject areas are breaking down to some extent, it is also true, we suggest, that the central analytical model of each field of liability remains distinct and recognizable, as does the measure of damages, typically yielded by each of the three theories. The central principle of the law of contracts, of course, simply being that promises are to be performed, pacta sunt servanda, as you were told at law school. The measure of relief almost invariably being the expectancy measure, enough money to put the plaintiff in the position he would have been in if the contract had been performed. You can recover the profits you would have made on the transaction. The animating principle of the law of torts, on the other hand, is that wrongdoers must compensate the victims of their wrongdoing, and the measure of relief is compensation, which will offset the injury in question. The basic principle of the law of restitution, as indicated already, the unjust enrichment principle, and the measure of relief, normally the value of the benefit conferred on the defendant, and obviously each of these measures may yield a different amount in any particular fact situation. Well, in a particular fact situation, any one of these theories or two or more of them may apply, and among the most interesting problems faced by private lawyers today, we suggest, is to determine when one theory ought to dominate at the expense of another, or alternatively, when concurrent liability, perhaps we can call it peaceful coexistence of two alternate theories of liability, is appropriate. There's now a long list of situations in which problems of this kind have surfaced. Peter and I have chosen 4 of them, 2 in which tort and contract theories may be said to compete, and 2 in which tort and restitutionary analyses both seem possible. And we will give these brief comment. I'm going to look at the problem of pre-contractual negligent misstatement, statements made during the performance of a contract, and the general question of Headley-Byrne liability. Peter will then look at the doctrine of waiver of tort and, if time permits, some discussion of breach of confidence. The decision of the House of Lords in Headley-Byrne and Heller was welcomed by many observers in the expectation that it might be possible to apply this new doctrine of liability in the context of contractual relations, or at least pre-contractual relations, so as to eliminate what had been a troublesome problem for the law of contracts. The law of contracts threw up a number of problems for an individual who had been the victim of a misstatement which induced him to enter into a contract. According to contract doctrine, you could only hold the maker of the statement liable if you could show that the affirmation made was a warranty and was so intended by the maker of the statement. The reported case law, as is well known, indicates that the courts were quite flexible on this question, but the reality in many cases was often that the statement was clearly made with a view to inducing the contract, but not with an intention that the fact stated would be warranted in the agreement to be true. Well, similar difficulties for such victims of misstatement, if you like, are thrown up by the parole evidence rule. I was told as a student many years ago at the University of Toronto that you could never lose a case on the parole evidence rule. In theory, it applied, but there were so many exceptions, you just couldn't miss. In the recent decision of the Supreme Court of Canada in Bauer versus Bank of Montreal, however, the parole evidence rule has received a strong reaffirmation, and the problem of pre-contractual statements, as it were, is still very much with us. Well, if you can't bring the statement within the agreement, then the question of what remedies are available, it's trite law that you can either sue for damages for deceit if it's a fraudulent statement, or rescind if the statement is innocently false. A more general solution to this problem was thought to be provided by Headley-Byrne, yet it was not obvious that this would be so. In Headley-Byrne itself, Lord Reed indicated some hesitation on this point when he said, where there is a contract, there is no difficulty as regards the contracting parties. The question is simply whether there is a warranty, throwing us back into the law of contracts. Mr. Justice Pigeon created difficulties for this hoped-for advance in the Nunes-Diamonds case by suggesting that statements made in the context of a contractual relationship could not give rise to tort liability. Relying on the Elder-Dempster decision, as Mr. Justice Pigeon's view that the two fields of liability appeared to be separate and distinct and could not apply concurrently. Well, on the other hand, if you read carefully the judgments in Headley-Byrne, you'll find a number of hints that perhaps liability in these circumstances should be imposed. And indeed, in 1976, the English Court of Appeal in Esso and Marden decided that this would be an appropriate form of liability to impose. Esso had misrepresented the volume of petrol that would likely be sold at a particular location to a prospective tenant. The tenant, relying on that statement, entered into the lease, lost a considerable amount of money. Esso then had the temerity to sue to enforce the lease. This fellow was not keeping up his rent, and he counterclaimed successfully in tort for the damages resulting from relying on this statement. 2 years later, the Ontario Court of Appeal in Sod Corporation and Tessus came to a similar conclusion. Here, the plaintiff had relied on an estimate by a trustee in bankruptcy with respect to the value of some stock, furniture. The plaintiff put in a bid on that basis, was successful, then lost his shirt, and successfully sued the trustee in bankruptcy on the basis of Headley-Byrne and Heller. Well, there's not a substantial volume of case law on this point, but I think one could, with some confidence, conclude that tort liability for negligent statement-inducing agreements is now recognized by our courts, although there are a number of problems as yet unresolved in the case law. The measure of damages is a point which will create difficulty in particular situations. In Esso and Marden, obviously Mr. Marden was to be compensated to the extent that he sustained a loss. He was not to be put in the position he would have been in if indeed he had had the amount of business he had been promised and had lived happily ever after with that level of success as a surface station operator. Rather, he was to be put back, if you like, in his pre-contract position with all of his out-of-pocket losses compensated. In an Alberta case, the measure of liability point is, to me, rather interesting. Pedant Construction and Resolute Construction, the plaintiff had successfully bid on a contract for the clearing of certain lands for a pipeline. The plaintiff based his bid on an estimate of lineal footage supplied by the defendant. The defendant's estimate was carelessly low, as they always are in these cases. And the plaintiff was allowed to recover for the additional work at the tendered rate of 80 cents per foot. Well, here he is allowed to claim damages on the basis of what would have been his contract price in the first place, and thus might be said to be in an even better position than contract damages would yield. Contract damages presumably would give him the profit he would have made if the contract or if the project had been, as it was alleged to be, a much smaller amount of work. Well, I assume that those problems are going to be resolved by careful construction of the warranty in a particular case so as to give us somewhat similar damages. The courts are not likely to want to come to the conclusion that tort yields a higher measure of relief than contract. Well, a further problem arises from the question of what sorts of relationships give rise to this duty of careful statement. In Hedley, Byrne, and Heller, the defendant was, of course, a banker giving a credit reference. In the later decision of the Privy Council in Mutual Life and Evatt, the court said that this liability, the majority of the court said that this form of liability could only appropriately be imposed on professionals, business people who are in the business of giving advice of the kind in question, and that point has created some difficulty in the negligent misstatement case law. In recent years in Canada, the courts appear to have been moving to a position that one does not appear to need special expertise of some kind. You don't have to be a professional person, an accountant or whatever, in order to engage liability of this sort. And indeed, manufacturers, for example, in the Saskatchewan case, a manufacturer of a prefabricated building advised his customer with respect to a contractor who might appropriately be engaged to put up the building. Turned out to be a very poor contractor, and that should have been known by the manufacturer. That was held to be a negligent misstatement engaging liability. There are, however, to be sure, in these cases, a number of statements which emphasize the professional expertise of the defendant in question, and I think it's rather early to jump to the conclusion, which some writers have come to, that the Mutual Life and Evatt reasoning is simply a thing of the past. In a recent English Court of Appeal decision, to underline this point, Lambert and Lewis held that the statements, carelessly false statements made by a manufacturer in his advertising material would not engage Hedley Byrne liability. The court said, amongst other things, the following: "We consider the cases of liability for statements volunteered negligently must be rare, and statements made in such circumstances as these are not actionable at the suit of those who have not asked for them." So there appears to be some inclination in the case law to award relief where there is direct contact and discussions between the plaintiff and defendant, but perhaps, if Lambert and Lewis is correct, perhaps not otherwise. Well, a number of the recent cases have dealt with the problem of exculpatory clauses or disclaimers, and it will be possible, if Peter is to have an appropriate amount of time, only to hint at the difficulties here. Hedley, Byrne, and Heller itself was a case in which the banker who gave the credit reference said, "By the way, I am not taking liability. I'm not assuming any liability with respect to the veracity of these statements." And that was held to be a basis for excluding liability in that case. The interesting problem which has arisen recently in the Canadian cases is whether or not an exculpatory clause in the subsequent agreement that the parties enter into will be considered a basis for engaging that aspect of the Hedley Byrne doctrine. And in Hedley Byrne, the banker, as he gives you the credit reference, tells you that you should not rely on his statement. Do we have the same sort of situation, Canadian courts have wondered, where you have someone entering into a contract which, in its terms, contains an exculpatory clause? Now, some people have suggested, some writers at least have suggested, that the subsequent exculpatory clause is of no consequence. the original trap has already been set. You've committed the tort of inducing this person into the contract. The fact that the contract ultimately has an exculpatory clause in it just means that the trap is a better one. It does not mean that you did not commit a tort in the first place. It seems to me rather more likely, and there's some basis for this in the Canadian cases, that the courts are simply going to construe the agreement and ask themselves whether or not the subsequent exculpatory clause fairly read has the intention of excluding liability for the prior tort. It seems likely, and this is argued at greater length, of course, in the paper itself, it seems likely that the courts will narrowly construe such provisions, and on the basis of the reported cases, it would appear that they are only likely to impose liability in a situation where the disclaimer or exculpatory clause, whatever it is drawn to the attention of the representee at the time when the statement is made. The cases in which liability has been imposed, the recent decision of the Supreme Court of Canada in Carman Construction, for example, is a case in which the representee, according to the holding of the court, knew at the time when the misleading statement was made that the agreement would ultimately contain a clause which said you can't rely on me for statements of this kind. The courts have not yet gone beyond the imposition of liability in such circumstances. But my second topic, which I will omit, was going to be the problem of negligent misstatement in the context of performing an agreement. And my thesis was about to be that the decision of Mr. Justice Taylor of the BC Supreme Court in Toronto Dominion Bank and Guest was rightly decided. That has proven to be a somewhat contentious decision. The court in that case stated that an employee, ordinary employee, who makes a careless misstatement to one of his employer's customers ought not be held liable on the basis of Hedley, Byrne, and Heller because he's simply doing his job, as it were. The fact that there's a contractual relationship between the employer and the customer suggests that that should be the sole source of liability which the customer can tap. He ought not be able to go to the poor employee and attack him directly. That decision has been criticized by a number of writers, including Mr. Justice Linden in his justifiably well-known text. And it seems to me there is an argument that can be made to defend such decisions. Putting it in very general terms, it places a very harsh burden on employees who have no choice, after all, but to engage in conversations of this kind with the employer's customers. Those employees who are only required to speak to other employees have no risk of Hedley, Byrne, and Heller liability. It seems an unfortunate distinction to draw that those who are required by their job description to talk to others are exposed to this kind of liability. The answer given by some is yes, but they are liable if they drive their cars carelessly, are they not? And it seems to me that that is a distinguishable proposition. They have a general duty, not just as employees, but as persons, to drive their cars carefully. The Hedley Byrne duty, which we're imposing on them in these cases, has as its sole origin, it seems to me, the contractual relationship between the customer and the employer. That's why we're able to say this is a situation in which he has a duty of care to make a careful statement. And on that basis, it seems to me the two situations can be distinguished, and that is essentially what Mr. Justice Taylor says in that case. I'll leave it at that and turn the microphone over to Peter Maddaugh.
For the next episode in this exciting story, Mr. Peter Maddaugh.
Let me get the microphone on here. Thank you, John. Well, to continue this examination of certain esoteric, if not downright exotic, issues in this fascinating borderland of tort, contract, and restitution, I'd like to turn to two further topics, one old, one new. The first concerns the doctrine known as Waiver of Tort. The doctrine has generated an undue amount of confusion and needless complexity. One source of this confusion stems from the doctrine's very name. As one commentator has aptly pointed out, it has nothing whatever to do with waiver and really very little to do with tort. Essentially, the situation is where a tort has been committed, but the plaintiff elects to bring his action, not in tort, but rather in indebitatus assumption, or as we call it today, restitution. In simple terms, the doctrine represents a branch of the law of restitution, whereby, in lieu of seeking damages to compensate for the injury suffered as a result of another's tortious conduct, the plaintiff requires the defendant to disgorge the unjust enrichment he has acquired as a result of such conduct. To illustrate, suppose the defendant converts my property. Later, he sells it at a profit. In tort, damages are the value of the property at the time of the conversion. However, the defendant has sold it at a price in excess of that value. Ought he be permitted to keep the windfall? By suing in restitution, I may claim the full proceeds of the defendant's sale. Or suppose that a publisher puts out a book containing libelous statements about me. That book, of course, turns out to be a bestseller. Rather than suing for damages that I've suffered as a result of the commission of the tort of libel, should I be entitled to waive that tort and require the publisher to disgorge the gains that he has made by way of his wrongful act? In other words, our theory of recovery here focuses not upon the plaintiff's loss in these situations, but rather upon the defendant's gain. It is this key feature that distinguishes restitution from both the law of tort and the law of contract. The term waiver is not meant to imply that one is condoning the tort that's being committed. This has been a source of particular confusion, and its roots go back to the history of the law of restitution. Waiver of tort cases, in fact, can be dated back in the 17th century, well in advance of the seminal decision of Lord Mansfield in Moses and McFarlane. However, in the 18th and 19th centuries, when restitution cases were being viewed in terms of quasi-contract, it was thought necessary to ground the action on some sort of consensual basis. This meant doing away with or waiving the tort. Not until the House of Lords decision in United Australia and Barclays Bank in 1940 was the fiction completely laid to rest. There it was recognized that the wrongdoing, the tort, was an essential ingredient to the action. Indeed, this is why the defendant's enrichment is unjust. Rather than having to elect between a tort theory and a restitutionary theory of recovery, the plaintiff may proceed to claim either form of redress, subject only to choosing his ultimate remedy prior to application for judgment. Putting aside the various technical and procedural squabbles that have surrounded the doctrine, most of which, like the election issue, have been happily resolved, there remains an important question as to the appropriate measure of recovery in these actions. For years, English courts were concerned with what I call the equation approach to restitutionary awards. Where the defendant has made a gain, it must be at the expense of the plaintiff. And further, to the extent recoverable, it had to be in a corresponding amount. It is this second aspect of the proposition that is troublesome. In Phillips and Humphrey, where the defendant trespassed upon the plaintiff's land and removed minerals, the court granted restitution for the value of the minerals taken, but not for the wrongful use and occupation of the land. Yet, in such instances, there is a very real loss to the plaintiff, namely, the opportunity to have rented his property to the defendant for a reasonable return. This approach was recognized in Strand Electric and Brisford Engineering in the 1950s and was placed squarely on the ground that a wrongdoer ought not be permitted to profit from his own wrongdoing. The logical extension of this rationale for recovery is that the defendant ought to disgorge any profits that he has made through his tortious conduct. Back in those unenlightened days when the law of restitution was shrouded in theories of implied contract, limiting the quantum of recovery to the rental or the resale value of the property was quite defensible. But now, having rejected these limitations, why should the plaintiff not be entitled to demand an accounting of profits in the same way as he could, for example, in the case of an infringement of copyright or for a breach of fiduciary duty? The Americans take an intriguing and somewhat pragmatic approach to this issue. Where the defendant is an innocent wrongdoer, the plaintiff's claim is limited to the reasonable value of the user. But where the wrongdoing is deliberate and intentional, the plaintiff is entitled to a maximum of restitution, including any profits derived by the defendant through the tort. Thus, in the famous Kentucky Cave case, Edwards and Lee's administrator, the plaintiff and the defendant owned adjoining properties under which existed a large cavern. Sole access to the cave was from the defendant's property, while the best scenic attractions were located under the plaintiff's land. Over a 5-year period, the defendant had built a hotel near the entrance and had run a large and profitable tourist business through the cave. In the waiver of tort suit, the court found that the defendant had committed a willful trespass, and in light of this intentional wrongdoing, awarded the plaintiff a share of the profits over the 5-year period proportionate to the area of the cave exhibited to the public under the plaintiff's land. The doctrine of waiver of tort indeed has modern-day relevance, and its potential is too often ignored. A case in point is the 1974 decision of the Ontario High Court in Townsview Properties and Sun Construction. The fact situation was perfect for the application of the doctrine, but unfortunately, it was not argued. The defendants were in the process of constructing an apartment and shopping complex near the corner of St. Clair Avenue and Yonge Street here in Toronto. The plaintiff owned the adjoining property and granted the defendant a limited license to enter upon his property for the purpose of demolishing 2 derelict houses. The defendant went well beyond the terms of this license and excavated a hole of about 20 feet wide and over 20 feet deep. This enabled the defendant to construct his foundation walls next door in a much more economical fashion. The breach of the license agreement, of course, constituted the tort of trespass. But normal tort damages were minimal in the circumstances, particularly since the defendant had subsequently filled the excavation. Indeed, the court awarded $479 being the cost of soil test and a further $500 for future tests. Nevertheless, the judge expressly found that the defendant had saved some $7,000 to $11,000 in expenses and some 2 weeks in construction time by virtue of his tortious conduct. In the result, $5,000 worth of punitive damages were awarded, a matter to which I'll return in a moment. Nevertheless, the defendant appears to have made a handsome profit as a result of his deliberate wrongdoing. Arguably, an action framed in restitution by way of waiver of tort would not have permitted the defendant to retain this windfall, and thus a glorious opportunity was lost. It has been argued that none of this is necessary in that the problem of a wrongdoer profiting from his own wrongdoing is amply protected within the traditional tort framework through the awarding of punitive or exemplary damages. Indeed, even in light of the severe limitations placed on that doctrine by the House of Lords in Rooks and Bernard, this particular area was expressly exempted. In a number of cases following that decision, where publishers of books or newspapers containing libelous or defamatory statements were found to have proceeded to publish, calculating deliberately that the profits would exceed any damages awarded in a tort action, the English courts have applied the second category of punitive damages outlined in Rooks and Bernard. But the device of punitive damages is somewhat makeshift and arbitrary as a method of preventing unjust enrichment. An examination of the decisions indicate that they invariably miss the mark. They are either too high, or as in Townsview Properties, they are too low. On the other hand, the defendant's gain can be measured with some degree of precision by an accounting of profits in a restitution context. No less an authority on damages than Dr. McGregor has stated, the resolution of these various difficulties may not lie very far away. It is to be found, however, by looking for assistance in a different direction. The key lies, it is submitted, in recognizing that the real purpose behind the second law category is not the punishment of the defendant, but the prevention of his unjust enrichment. Accordingly, the second common law category is more appropriately viewed as an extension of the remedies available through waiver of tort and by way of an accounting of profits. Perhaps the law should now be regarded as in a transitional phase, moving towards the time when the use of exemplary damages is superseded by the extension of the direct and more appropriate remedies as a mean for ensuring that tortfeasors are not permitted to retain the profits made by them through their tortious conduct. Waiver of tort is but one example of the general restitutionary principle that a wrongdoer ought not be permitted to profit from his wrongdoing. This general principle covers a broad spectrum from the obvious and blatant acts of criminal conduct, such as theft or extortion, to more subtle wrongs traditionally only recognized by courts of equity, such as undue influence or unconscionable transactions. The second topic which I would like to examine today falls at this subtle end of the spectrum, breach of confidence. This form of equitable wrongdoing involves the abuse of information which is given in confidence. There now exists a clear line of English authority to the effect that relief will be granted for a breach of confidence even in the absence of any fiduciary or contractual relationship between the parties. That a claim based upon breach of confidence is not limited to cases where the parties are in a contractual or fiduciary relationship or upon tenets of property law was expressly confirmed by Lord Green in Saltman Engineering and Campbell Engineering in 1945. He stated the principle as follows: if a defendant is proved to have used confidential information directly or indirectly obtained from the plaintiff without the consent, express or implied, of the plaintiff, he will be guilty of an infringement of the plaintiff's rights. Indeed, the recognition of breach of confidence as a distinct basis for relief can be traced back as far as 1849 to the case of Prince Albert and Strange, a case that involved the surreptitious copying of certain royal etchings and the subsequent preparation of a catalogue therefrom. By and large, the English cases have involved the violation of trade secrets and confidential commercial information. In cases subsequent to Saltman and Campbell, the contours of the action have been more particularly defined. In Coco and Clark, Mr. Justice McGarry sets out the three elements required. 1, the information must have the necessary quality of confidence about it. 2, the information must be imparted in circumstances importing an obligation of confidence. And 3, there must be an unauthorized use of the information to the detriment of the party communicating it. And in Fraser and Evans, we are told there are exceptions, that in some cases, it is in the public interest to have the information disclosed, despite its confidential nature. Thus, in Church of Scientology versus Kaufman, where the plaintiff sought to restrain the publication of a book disclosing the methods and practices of Scientology, the court concluded that it was in the public interest that such nonsensical mumbo-jumbo be disclosed when the plaintiffs were seeking such large fees from the public to take its courses. These English trade secret cases typically involve the defendant making a gain by virtue of his breach of confidence. An accounting of profits is often awarded, particularly where the wrong is found to be committed intentionally. Where the abuse has been committed innocently and in good faith, as in Seeger and Copydex, recovery has been limited to the market value of the confidential information disclosed. Interestingly, this is the exact same distinction between innocent and intentional wrongdoing and the consequent measure of restitutionary relief that the American courts have adopted in the waiver of tort cases. From a restitutionary point of view, the breach of confidence cases rest quite comfortably beside the waiver of tort cases. But apart from the restitution interest, the prevention of an unjust enrichment, there are other interests deserving of protection. When a patient discusses intimate feelings with a psychiatrist, or a taxpayer gives financial records to an accountant, there is ordinarily an expectation that such matters will be held in strict confidence. In 1924, Lord Justice Scruton could state, "It is curious that there is so little authority as to the duty to keep customers' or clients' affairs secret, either by banks, counsel, solicitors, or doctors. The absence of authority appears to be greatly to the credit of English professional men, who have given so little excuse for its discussion." However, authority is developing in this area, and what appears to be emerging is a new tort. In the United States, the action is still in rudimentary form, but recent case law has clearly articulated the basis of recovery in terms of a separate and distinct tort. Similarly, the British Law Reform Commission, in its report to Parliament on breach of confidence, has recommended that the existing equitable and legal rules governing breach of confidence be supplanted by a statutory reformulation of the action as a tort, with a single set of principles applicable to all kinds of confidences and accompanied by a broad range of remedies. Certain relationships require candor and cooperation. To foster this, those who advise or assist us hold forth an assurance of secrecy. Such an assurance may arise out of customary practice, common understanding, or through professional codes of ethics, or even by statute. Whether formalized or not, the assurance of secrecy is vital to the success of the relationship. This assurance evokes a corresponding degree of reliance. There are a number of interests deserving of protection here. The aggrieved party has a general interest in the security of the confidential relationship and the corresponding expectation of secrecy, and a specific interest in avoiding whatever injury will result from the circulation of the information. A breach of confidence also jeopardizes certain societal interests. There is an interest in confidential relationships to matters of health, education, and commerce. The law relating to testimonial privilege has long recognized a similar societal interest. To be sure, legal relief has been awarded in breach of confidence cases in the past, but the legal theory employed has been far from uniform, covering such areas as invasion of privacy, implied term of contract, or implied private cause of action arising out of statute. Part of the confusion stems from the courts focusing upon the nature of the injury involved: damage to reputation, embarrassment, related harms. This has tended to lead to basing liability on the tort of invasion of privacy. This approach, however, fails to deal with the expectation of confidentiality and the resultant reliance. It also tends to deal with the question of privacy in the context of the public at large, whereas breach of confidence situations may involve dire injury where the disclosure is made only to one person, perhaps an employer or a spouse. Other courts have focused on the conduct giving rise to the injury, the breach of the obligation of confidence. This has tended to lead to an analysis of the facts in terms of contract or some statute prohibiting the conduct. This approach does not accord with reality. Obligations of confidence arise out of common notions of decency and social policy fostering particular relationships, not bargained-for terms. Banks and doctors, for example, do not offer lower rates if a customer or patient does not insist upon confidentiality. While contract may frequently establish the relationship, it is tort law that imposes the duty of confidence. Neither approach it is submitted is adequate to deal fully with breaches of confidence. Recent U.S. cases have placed the theory of liability squarely on the basis of a general duty to keep a confidence, the breach of which results in the commission of a tort. The object is to compensate for resulting injuries and not the fulfillment of expectations. Recognition of breach of confidence as a distinct tort would address squarely the individual and societal interests at stake in a confidential relationship. Such a tort remedy available, courts confronted with a compelling case of breach of confidence will not be left to manipulate haphazardly the remedies offered by theories of liabilities developed for other wrongs. It has the additional advantage of opening debate about the tort's proper scope and of extending it to cover other relationships beyond those which the courts have recognized to date. Finally, returning to the English trade secret cases, rather than forming a maverick collection of examples of restitution based upon some sort of equitable wrongdoing, if a distinct and separate tort of breach of confidence were recognized, then these decisions simply become modern examples of the application of that mystical doctrine that one pleader of old described in the following couplet: "Thoughts too deep for tears disturb the court, when I a sumpsit bring, and godlike wave the tort." Thank you.